I'm going to title this blog, The Evils of Speculation by a Medical Provider. Let me explain. When a doctor writes a report in a personal injury action or testifies in that personal injury action, the doctor has to make conclusions to a reasonable degree of medical certainty. The standard has to be to a preponderance or more likely than not. So what happens if the doctor says this could be due to the accident? That, the word could, is speculative, and that will not be sufficient to satisfy a judge and will not be sufficient, I would argue, in the negotiation of a personal injury case settlement. Could is speculative. More probable than not gets you the conclusion that is necessary, although it is a rather tepid conclusion, I would say. It is best when a doctor can make pretty strong statements on things like causality and prognosis, because A, you will get above the judicial standard, and B, it has a ring of credibility. But anything that is less than the standard expected, such as the person could have had this problem because of, the court will not hesitate to say it is speculative, and therefore everything that follows from that conclusion is to be stricken. This came about in the recent case that I blogged about of Fife versus the MBTA, where the appeals court set aside a rather large verdict for the person who sued the MBTA in a case where liability wasn't contested and the only issue was damages. Now, down the road, a person could be at risk for developing an injury in a much greater way than a person in the population. That could be because, for example, post-traumatic arthritis is possibly going to develop, and certainly more so than as compared with somebody from the general population. I have argued successfully that that is an issue regarding increased risk of developing something, and you will get that conclusion admitted into evidence or factored in by the insurance company in negotiating a settlement. But to be sure, that is different from the proposition of saying this injury or medical condition could have arisen from the accident. That is not sufficient. So keep in mind the standard that has to be satisfied, and that is to a reasonable degree of medical certainty, at least by a preponderance of the evidence. Thank you.